Welcome to another edition of Matters of Law. Matters of Law, the law reigns supreme. Join us on extvgh on YouTube and extvgh on Facebook. Hope you have enjoyed all the sessions we've had. And indeed, we wish to apologize for our inability to bring you a session last week. Let's go for a spot of commercial. We'll be right back.
This program is brought to you by PEG Enterprise. Call us on 0240 533 097, 0240 533 097 for your delicious pastries, cookies, and drinks. Locate PEG Enterprise near KK House in Ho.
Welcome back. Today, we are discussing how to apply for letters of administration. How to apply for letters of administration. Now, one of the things we need to know that when anybody gathers any property, anybody makes any property, and when the person dies without making a will, the law requires that you cannot deal with the person's property without applying for letters of administration. So if the person didn't make a valid will under the Wills Act, and the person dies intestate, meaning the person died without making a will, then for you to deal with the property that the person has acquired, be it land, be it a house, be it a car, be it any sole proprietorship business, be it anything including the person's personal effects, you need to apply for letters of administration. Question: where do you apply for these letters of administration? Is it just a letter? Is it just any document that you can just go and ask for? You apply for letters of administration at the court. Usually, people may go to the district court, or go to the circuit court, or go to the high court to make the application. A lot of the times, it depends on the value of the said property. You need to understand that for you to apply for letters of administration, you must fall within a particular category. One of the categories is that you are a surviving spouse of the person, meaning legally married wife, be it under customary law or under the ordinance. Or another category of persons is that you are a biological child of the said person, or you are an adopted child of the said person. Then the third one will be relations of the deceased person. So maybe the brother, the sister, all of them fall within the category. Now, I have mentioned about 3 people who are legally entitled to apply for letters of administration. There could be a representative from each of these 3 groups who apply for letters of administration. Now, applying for letters of administration does not make you owners of the property. You are always advised that at any point in time that somebody dies and you want to apply for letters of administration, you will seek the services of a lawyer, no other person than a lawyer. The things you need to gather before you apply for letters of administration, the first one is the death certificate, or what we call the cause of death, then probably a burial permit. You may also need a funeral poster or brochure of the said person who is deceased. You need the residential address of the person, the last known residential address of the person at the time of his death, or where the person had majority of his property at. Usually, it's advisable to apply for letter of registration at where the person last stayed, or within the region where the person last stayed before his death. You would also need what we call the head of family affidavit. Now, the head of the family you come from would definitely post an affidavit stating that the applicants therein, be it a surviving spouse, children, or any other person, were selected by the family to apply for letters of administration. Now, aside the head of family affidavit, you also need the affidavit by the applicants. So all the applicants or any of the applicants will need to depose to an affidavit, make statement that yes, indeed, they are the applicants, they are either the children of the deceased person or they are surviving spouse of the deceased person, for which reason they are applying. They need to state where they are staying and all the necessary details about them. They would also state in that affidavit the date of death of the said deceased person, the necessary attached documents as to his last place of abode and things like that. We need all that document. You'd also need a document which we call the assets declaration. So all the assets that belong to the person, by that I mean the properties of the person, will be listed on that document, and that document there will be a valuation of the said asset. So if it is 4 houses, you state the 4 houses, you indicate where each of those houses are, and you put a value, you value those said houses and write the value there. What a lot of people do is they either omit some of the properties in the said, some of the properties belong to the said person, or they will decide to underdeclare, so they'll quote lower values, with the mindset that when they have to pay what we call the estate duty, and for all the properties that are going to be declared, there's an amount of money that you pay to the state called the estate duty. Usually they undervalue it so that they pay lower estate duty, but that is a wrong practice. Because when you go and you need to assess any property or you need to deal with that said property, you will definitely come and do what we call the enhancement. So it is not good for you to either take some of the items out. In any case, if you take any particular property out, remember that property is not covered under the letters of arbitration, and you cannot deal with that property in any way that you wish to deal with it as required by law. Now, when you have these necessary documents, you see a lawyer and they will prepare the application for the letters of arbitration should be issued in your name. When they prepare it and you sign or you depose the affidavit, by that I mean you make the declaration in the affidavit, it will be sent to the registrar of the court. Then the affidavit will be commissioned or to the commissioner of oath, and those affidavits will be commissioned. They will attach it to the motion paper for the application for the letter of arbitration, and it will be filed in the court, either at the district court, at the circuit court, or at the high court, depending on the value of the estate or the amount that is involved. Remember, aside all these houses and other things, if there's money at bank or there's shares anywhere, all that will have to be declared. Now, with the said document and having filed the application before court, they will set a date by which you should appear in court for the court to hear your application. On the said date for the hearing of the application, you should, as the applicant, be present in court. Every single applicant must be present in court, and it's advisable that the family head is also present in court. So one way asks, what if the family head is refusing to depose to an affidavit, or these applicants have a challenge with the family head? You will need to discuss with your lawyer to find the best way by which there can be a deposition to that effect. In any case, if the family head is refusing to depose an affidavit for the benefit of the applicants or for the benefit of the application, he can still take steps to ensure that the application is made. That's the most important thing that you need to know. Now, when you appear before the court and the court listens to your application and it's satisfied, the court will grant 21 days for which the notices of the said application are to be posted. The notices may be posted at the last known place of abode of the said deceased person on the court notice board, and certain places the court finds it prudent for such notices to be posted. Remember, all this information as to where the notices are to be posted will be provided in the affidavit that you are sending. Now, if the court grants you that order for the notice to be posted in 21 days, you have to ensure that these notices are posted. So you see the court bailiffs, you see the registrar, and they post these notices. Now, when these notices are posted, if anybody have any reason why you should not be granted letters of arbitration, the law allows them to come and do what we call a caveat. For instance, a property may be included in the list of assets. That property does not belong to the deceased person, or some other people may feel that they are entitled to apply for these letters of arbitration, and that the applicants are not the only ones to apply. They are allowed to caveat. If they do caveat, the court, and by that I mean it's a process, legal process, you need to see a lawyer to help you with that process, to file a process indicating that indeed you have interest in the said application that is going on. If no caveat is found, then what it means that after the 21 days, these applicants will come before the registrar, and the registrar will grant them or will give them the certificate. Now, in giving the certificate, you are required to pay what we call the estate duty. Let me also add at this point in time that if you seek the services of a lawyer, this whole process of applying to the court, you would pay for those services which are being rendered to you. Now, if you get the certificate as administrators of the estate, with that, then you can go ahead to ensure that the property is shared according to PNDC Law 111. I think we have had a discussion on this and the categories of persons who are entitled to benefit under PNDC Law 111. But the key thing you need to know that if somebody caveats, then the court will make a determination, or the court will move ahead to ask you, well, whoever has caveated should probably bring a suit against the parties involved, so that the matters in contention are resolved, or the court may ask the parties to try and resolve it. One of the key things we need to know that even in all of this, the interest of a child who has not attained 18 years but who is entitled to benefit under the estate, the law requires, and for the protection of such a child, that somebody stands in a position we call in loco parentis for such a child. Now, all of these will be decided on during the application. So once all of that is done, the administrators now have the legal rights to be able to represent the estate in case somebody wants to bring a legal action against the estates, that the properties of the person. That person will have to sue the legal representatives or the administrators of that particular estate. Now, I wish to make the point clear that the administrators do not become owners of the said property. Their duty is to ensure that the properties are shared according to PNDC Law 111. Should it happen that they do not comply with the requirements of PNDC Law 111, you can go back to the court, contact the registrar, so that certain steps will be taken to ensure that the property is shared according to law. Indeed, any administrator who does not comply with the requirements of the law puts himself in trouble. So it's important that as at the time you are applying as an administrator, you stick to the clear rules. Having said that, it is advisable to prepare a will so that you determine who should take what property and the quantum that the person is supposed to take. All these help in you deciding how your property is supposed to be shared. I believe we've had a discussion on wills, so you can go back to that video and have an extensive understanding on how to prepare a will. I hope you learned something from this particular session. We talked about how to apply for letters of registration. In summary, we said you have to apply to the court, you need to see a lawyer, you need to get a death certificate, you need to get a burial permit, you need to get a funeral brochure, list of the items or the assets of the person. There will be some valuation that is stated on the form. A lawyer will file the application. The court may grant 21-day notices or notice to be posted for 21 days. And after that, you pay your estate duty and you be granted the certificate, which is the letters of administration. If any of the things we have discussed you were not able to understand, or you have any questions, you can send it on our various social media platforms, on YouTube and on Facebook. We are ready to respond to you. And thank you so much for being part of us. We say matters of law, the law reigns supreme. Make time with us, same time next week. Bye-bye.
To support this program, contact XTV on 024-606-1095 or 050-836-4159, or send us an email to info@stvgh.com.